be seated. This is the time set for argument in the case of Flynn versus Campbell, our civil number 15-0278. Each side will have 20 minutes within which to present their arguments here this morning. The appellant may reserve some portion of that for rebuttal. However, you'll have to keep track of your own time in that regard. We have reviewed briefs and the record, and are familiar with the arguments advanced that you intend to advance in this case. In fact, we conferenced this case this morning. The last thing I'll note is as you approach the podium, please identify yourself and your client for purposes of our record. We are actually keeping a audio and video record of these proceedings, and in a matter of weeks, if you're really interested, you can actually go to YouTube and watch the argument. With that being said, appellant may proceed.
Good morning, and may it please the court. My name is Melissa Iyer-Julian, and I represent the appellants Diane and Robert Flynn. I'd like to reserve 3 minutes of my time for rebuttal. The central issue in this case is whether or not the amended complaint Robert and Diane Flynn filed within 5 weeks of the statute of limitations running relates back in time pursuant to the requirements of Rule 15C. Rule 15C has 3 requirements. First, that the transaction and the amended complaint arise out of the same transaction as that set forth in the original complaint. Notice to the defendant so that they are not prejudiced by being brought into the suit, and knowledge that but for a mistake concerning the identity of the proper party, the defendant knew it would have been sued. Now, in Pardman v. Vickers, this court held that knowledge and notice can be satisfied where a defendant's insurance company received notice and knowledge within the time limits required by Rule 15C.
Is this a mistake of fact or a mistake of law?
Well, I think in addressing that, first I have to point out that Rule 15C doesn't actually make a distinction between mistakes of fact and mistakes of law. The concept of a mistake of law is a label that has been placed on the rule by courts in identifying a failed litigation strategy where a lawyer pursues, with full knowledge of all the potential defendants in a case, pursues particular defendants to the exclusion of others based upon a strategic decision. This court's decision in O'Keefe v. Grenke is a perfect example of that. There, the lawyer was fully aware of the intervener defendants. He knew and even referenced them in his original complaint. What he testified to, though, in relation back, in support of his relation back argument, was that even though he knew their role and that he could sue them, he did specific research on the bulk sales claim and determined that he didn't have to sue them. So he made the strategic, tactical decision not to. And what the court held in Grenke, which is where that language mistake of law made by counsel comes from, the court said a strategic decision by counsel doesn't constitute a Rule 15C mistake.
Would it be a strategic decision to sue this party when you know you really should be suing that party, or does that matter as long as it's intentional, strategic?
Well, I think the key is what you know. And the reason for that is in Timon v. Hintz, the court set forth the test for determining what constitutes a mistake for purposes of Rule 15C. Timon said, following Leonard v. Perry, that what the plaintiff actually knows and actually believes is the relevant datum for determining whether or not a Rule 15 mistake occurs. It's not whether it was a reasonable mistake, whether they should have known. It's analyzing what they actually did know from a subjective perspective. In this case, Diane Flynn testified by affidavit, and that wasn't controverted, that she negotiated exclusively with State Farm, that they told her they were assuming full responsibility for the actions of their insured.
Let me ask you about the affidavit. I thought the court in the trial court in its ruling did not accept the affidavit and did not allow this to be treated as a motion for summary judgment.
Well, the trial court did state in its minute entry that it wasn't considering the affidavit,
Right.
but that in and of itself was an error.
Well,
because if you look at...
forgive me, did you argue on appeal that the court should have considered the affidavit and mistakenly or erroneously, whatever, failed to do so? I didn't see that issue.
I did not identify that as a separate issue.
Okay.
But
Okay, if it's not an issue, let's assume you haven't waived it for a moment. Do you have some authority that says that we as an appellate court can rely on matters outside of the pleading when the trial court explicitly said it was not doing so?
Well, for purposes of this particular analysis, Timon does say that a trial court is supposed to consider affidavits and evidence because the plaintiff bears the burden of demonstrating a mistake and can only do so by submitting affidavits, just like Diane Flynn did here. And so for purposes of evaluating whether or not the trial court abused its discretion in granting the motion to dismiss, this court is looking to the record to identify whether or not it failed to consider the evidence that supported her burden of proof on whether or not this constituted a Rule 15c mistake. And that evidence does demonstrate, as well as I think it's also just clear from the face of her complaint, that when she filed suit against State Farm, based upon her subjective understanding, that she believed she was suing the proper party. This isn't a situation where she made a strategic or deliberate choice. She believed, based upon representations they made to her and her untrained knowledge, she wasn't a lawyer, that when they told her, we are responsible for the actions of our uninsured. If you want to be paid, you have to deal with us. She thought that meant she had to sue State Farm in order to recover for the injuries that she suffered in this accident.
So she wasn't making a decision as to who not to sue, a strategic kind of a play.
Exactly.
She was suing the one person who said, I'm your guy.
Exactly. And that is what she believed at the time that she filed the original and timely lawsuit, which is why it does constitute a mistake in identifying the proper party for purposes of Rule 15c, and not a strategic decision like the decisions at issue in Grenke or in the Howard case that was provided as supplemental authority. That case is also distinguishable on the same basis. There, the lawyer knew that these individual doctors and nurses could be named, but elected not to name them as defendants based upon a strategy. Now, ultimately, that strategy was a poor one because assumptions made about vicarious liability turned out to be wrong. But it doesn't change the analysis that in that case, the lawyer knew, I can name this doctor, but I'm choosing not to. That's the difference between the knowledge of the party in Howard, the actual knowledge of the party in Grenke, the difference between those parties and the knowledge that Ms. Flynn had in this case when she filed suit. And that is the relevant datum based upon Timon that this court should consider for purposes of determining whether or not she qualified under the mistake requirement for Rule 15c2. And again, I'd like to reiterate that the party that she mistakenly sued isn't just a party that's totally unrelated to the new defendant. The party that she sued was the defendant's, admittedly, the defendant's liability insurance company. And as this court recognized in Parkman, the insurance company stands in a position as a real party in interest to the case. They have a duty to indemnify and defend its insured. And so for purposes of the rules of civil procedure, and in many instances, the insurance company is permitted to step into the shoes of the insured for purposes of setting aside defaults. When it's bringing a subrogation claim in Safeway Insurance Company versus Collins, the insurance company failed to identify it's insured as a party plaintiff for purposes of its subrogation claim. And this court said you can get the benefit of relation back to add in your insured because your subrogation claim isn't ripe yet. We're going to give you the benefit of that relation back because of your status as a real party in interest and your relationship, the identity of or unity of interest that the insurance company has with the insured. So,
I'm sorry, go ahead and finish your thought, please.
well, in that, because of that relationship and the insurance company's ability to utilize that relationship with specific reference to Rule 15C, what I'm saying is they can't use Rule 15C as both a sword and a shield. If a status as real party in interest is utilized for one purpose under Rule 15C, then it's utilized, as this court recognized in Pargman, for purposes of not only the notice requirement, but also the knowledge requirement. And it's clear from the face of the complaint and from the undisputed testimony Ms. Flynn provided that when she filed her complaint, she made a mistake. She didn't understand the difference between an indemnitor and an indemnity. She thought she was suing the proper party.
Question for you. I think we all agree that there's plenty of case law out there that says that in this type of case that the insurance company is not the proper party. Fair?
Fair.
Is that waivable? Is it possible for the insurance company to say, we're going to carry the load here, we're going to be the person you should sue us, and feel free to understand that we're waiving our rights under that case law? Could they do that?
I think they probably can, because what the case law says is that in the absence of a contractual or statutory provision that enables a party to directly sue the insurance company, there is no direct action. Some states actually do have statutes that provide that you can sue the insurance company, and certainly the insurance company can separately contract to become responsible to be liable in a direct action on behalf of its insured.
So it is possible that if a course of conduct was followed by an insurance, it's your position, that if a course of conduct was followed by an insurance company that went far enough, and I don't know what far enough means, but they might waive the right to claim the protection of those cases and be found to have taken on the liability of the insured.
Yes, I think that's possible. I don't have any specific authority that deals with that particular situation, but I think that the conduct of the insurance company or the defendant in cases that have dealt with this issue do certainly consider the conduct in determining whether or not a Rule 15C mistake is made. Krupski is an example of that too. What the Supreme Court said is the defendant's conduct in putting two different names on the ticket, in misleading the potential plaintiff into misidentifying the proper party, is relevant in determining whether or not a mistake has been made, because the C2 itself doesn't just say focus on the plaintiff's mistake. It also focuses on the defendant's knowledge of the mistake, what they knew or should have known.
Well, clearly State Farm knew. Let's get real.
Yes.
I mean, they do business in this state. This is a state that is clearly, since I guess 1903, made it clear that you don't sue insurance companies in this type of situation. So this is not a direct action state. So clearly, there's no question about it. So with that in mind, I think the hard issue in the case is the mistake issue, and I hear your argument is basically that a mistake of law is shorthand or a code that our courts have used for a strategic decision, a tactical decision that turns out to be a mistake, so to speak. It ends up failing. And that didn't happen here because Ms. Flynn, had been assured by State Farm that they were going to be responsible. Right,
and these are fact-sensitive inquiries based upon the test that was adopted in Timon, and so the concept of a mistake of law is something that is driven by the facts of the particular cases that were addressing that issue. And when you look at those cases, they are always coupling that finding with a finding that it was a strategic tactical decision, and there is, just based upon the plain language, a difference between a strategy and a mistake. And so those cases aren't wrong. They simply aren't applicable here, where we have a party who wasn't engaged in any kind of litigation strategy.
Let me ask you, Ms. Julian, if we were writing this decision and we said, okay, there's a difference between a mistake and a strategic decision, how would we describe that in our decision so that trial courts would have some guidance?
I think the important thing to identify for the trial court has already been identified, which is you evaluate the knowledge of the party at the time they filed the lawsuit. It is a subjective test, and if they understood not only if they understood all of the factual and legal differences between the two parties, that's what the Supreme Court identified in Krupski, then certainly a deliberate decision to sue one party instead of the other, when a party has full knowledge of both factual and legal differences, doesn't constitute a Rule 15 mistake. But the court in Krupski also said, just because you know a party exists doesn't mean you don't make a mistake about their role or status. So the guidance from Krupski could be very useful for this court, and I think it's important too to point out that, as the committee notes point out themselves, Rule 15C was adopted from the federal rules. Even the comments or the committee notes say, we don't really have this problem with people misnaming agencies, but we want our rule to be consistent with the federal rule, so we're adopting it. And so throughout our history of interpreting Rule 15C, we have taken guidance from the federal jurisprudence on how to construe that test, how to construe the requirements set forth in it. So I think it's appropriate also in identifying the difference between this case and prior cases that have addressed this issue to look to Krupski to identify differences between mistakes that qualify and mistakes that don't. Thank you. I'll reserve the remaining time for rebuttal.
Thank you, counsel. Mr. Barnes.
May it please the court, I'm John Barnes for the defendant, Sarah Campbell. The Flynn's did make a deliberate decision not to sue Miss Campbell in this case. They knew that she was in control of the other vehicle involved in the accident. They just confused the State Farm's duties to defend and indemnify its insured with direct liability.
But isn't that an attorney's perspective?
Well,
isn't that strictly an attorney's perspective? They should have known based upon the person who was driving the vehicle at the time of the accident, as opposed to having State Farm say to them, we're your guy.
Pro per litigants don't get special treatment because they don't have a lawyer. They're held to the same knowledge of the law as a lawyer. And there are plenty of cases on that in my brief.
Well, I certainly understand the concept. I'm wondering if it applies here. Go ahead.
We know that.
And my question, it goes back to your opening statement. Yeah. You said they were confused. And my question is, so who caused the confusion? Isn't it a reasonable inference here that State Farm caused the confusion if we consider the affidavit?
Well, if you look at what State Farm said, it said it would, according to the affidavit, we're going to handle the claim and we're going to pay for the injury. So, in other words, we're going to defend and indemnify our insured.
Well, they said they assumed full responsibility.
That's what the complaint says, Judge. The affidavit that clarifies, this is the affidavit from the plaintiffs. It clarifies what they mean by that.
Well, okay, hang on. Do we consider the affidavit or not? You want us to consider it? Yes or no?
Well,
no, just please answer my question, please. May we consider the affidavit?
Judge, you can if you want to,
okay.
But it doesn't make a difference.
Okay. Well, if it doesn't make a difference, let's assume we're going to consider it then. In the complaint, Ms. Flynn alleged that, she clearly knows that Ms. Campbell caused the accident, but she alleges that State Farm had assumed full responsibility for its insured's actions. Full responsibility to a person. What does that mean? It means they're responsible. Okay, I guess I better sue the responsible party.
Well, Judge, I just heard you say that we're going to consider the affidavit.
Okay, let's look at the affidavit then.
So
okay.
The affidavit clarifies what they meant by that, and it says that they believe State Farm was going to handle the claim and was going to pay for the injuries.
Well,
defend.
I think you're drawing a distinction that is really right, kind of like trying to split a hair, which is, okay, I've been told they're responsible, and now I've been told they're going to pay for the injuries. I'm not seeing a distinction between I'm responsible versus I'm going to pay for the injuries. To me, as a normal human being, taking off my lady lawyer hat, but just acting like a normal thinking person, I would think that's about the same thing. I'm not sure I see a distinction.
Judge, I
I
don't
see
think
what you're trying to do by parsing it through, but I don't think I see the distinction.
it doesn't matter one way or the other whether there is a distinction or not, because at the end of the day, what happened was a mistake of law. We know that negligence liability requires duty breach causation damages. The Flynn's never thought that State Farm breached a duty or satisfied any of the other requisites of liability. And if you read Timon, that's what it says has to happen for a mistake of identity under Rule 15C to happen. You have to have a mistaken belief that the wrongly named defendant is liable. And the Flynn's just never thought that. They might have, made a mistake of law in what they thought liability means, but that does not qualify as a mistake of identity.
So what we've got is basically something that, to use a phrase stolen from another area, we have a mixed question of fact and law, right?
No, it's a mistake of law.
Purely.
Yes.
Okay, so the assertions made couldn't lead to factual confusion.
Not on this record, Judge.
Hence
Well,
my question
yeah.
about waiver earlier. There are all kinds of things that can come to play in the course of this, but none of those count as long as we can call this a mistake of law, right?
Judge, I mean, in theory, I don't have any basis to disagree with you, but there's nothing here in this case that suggests that that's an issue here. I mean, it wasn't raised in the trial court. It wasn't raised in the briefing. It's just I don't see where that came up in this case anywhere.
What didn't come up?
The issue of waiver that you're.
And I'm not saying purely waiver. There are things that can happen in the course of this that take that line and move it back and forth as regards whether it's a mistake of fact or a mistake of law, right?
And my point, Judge, is that you might be right, and that might make a good law review article, but it's not something that goes in the decision in this case because it's not an issue here.
Okay, paragraph 3 of the affidavit says, my husband and I believe that State Farm would be paying for the injuries I sustained in the collision. I'm struggling here because in the complaint, the original complaint, Ms. Flynn alleged that State Farm had basically assured her it would be responsible. Paying for the injuries and being responsible seem pretty much the same thing to me.
Well, Judge, I mean, the language you just used there, isn't that not the definition of indemnify?
Paying for the injuries.
Paying for the injuries of its insured?
Excuse me, I don't see anything in here that says, well, we're going to be representing Ms. Campbell, and of course, she'll be the responsible party. What I see is allegations that State Farm was going to be the responsible party. Let me give you an example, and it's not a perfect example, but it's the best one I can come up quickly. My daughter goes out and does something improper or wrong. She's negligent. And she injures my neighbor's property. And I walk over there and I say, I'm responsible. I'll take care of it. Okay? I didn't cause it. Maybe she's an adult. She could be responsible. But I go over to my neighbor and I say, I'll take care of it. I'm responsible. But I didn't cause it. Now, the neighbor says, well, okay, who should I be suing? The daughter, my daughter, or should I be suing Norris because Norris said I'll be responsible, but I didn't cause anything. So what? So what? So she sues me. She should be suing the neighbor sues me, but she should be suing the daughter. Isn't that a mistake? Isn't that what happened here?
With all due respect to your hypothetical, the bottom line is what happened. Your hypothetical doesn't have anything to do with an insurer and an insured, and because
no, it has to do with reality and how humans behave and what people think about actions and mistakes. Let's talk about
precisely, Judge. And in this case, the Flynn's didn't know what it means to indemnify. The role of an insurer is to indemnify its insured. And what you're
aren't
leading
you making
to
the argument that we're asking you about? If
that
they
is a
didn't
mistake
understand the role of an insurance company, isn't that a mistake of fact?
Of law. They didn't know what the legal landscape was in terms of the insurer's role in this case. That's why they sued the insurer.
Based on the representations that State Farm made.
If that were the case, then every time an insurer says to anybody that's not a lawyer, we're going to indemnify our insured in this case.
See, that's not what is alleged. This is the record we have. We have the complaint and the allegations, and we have this affidavit. That's what we've got. We don't have other facts that we look at. And there's nothing in here that says, I was told that State Farm would indemnify Ms. Campbell.
No, it said it was going to pay for the
Injuries.
injuries, which is the same thing.
Well, excuse me, that's not what this says. This is not the same thing to people. This is what they allege.
Well, no,
and we look at whether there's a mistake from the standpoint, don't we, of the plaintiff here? As Ms. Julian explained, relying on the case law, I think Kopinski and the others?
Well, what we're talking about is the mistake of identity portion of the rule, and absent that, it doesn't matter who had notice or excuse me, who had knowledge of the mistake if it's not a mistake of identity. And so, I mean, to answer your question, Judge, it doesn't matter.
Let's get back to my hypothetical. The neighbor sues me. Okay?
Okay.
Is that a mistake, a fact, mistake of law? What is it?
I don't remember the premise of your
Okay.
your hypothetical there, Judge.
My daughter, who's an adult, damages my neighbor's property through negligence. I walk over to my neighbor and say, I know she did it, but I'll be responsible for this. I will pay for the injuries to your property. And they sue me.
So there's no mistaken there's no mistake of fact that you caused the
I didn't cause it.
So that's not a mistake of identity. They don't think that you caused the whatever damage happened.
Right. But they sue me.
They know that your daughter.
right.
They sued you. They're trying to cut out the middleman or something. You're the deep pockets. That's why they're suing you, not because they think that you're responsible for causing anything.
Now back to my, if I may
Okay.
cut in for a second, back to my question earlier. State Farm said, we will assume, we will engage in an assumption. I think that has some legal ramifications to it. An assumption of full responsibility for your injuries in this case. Now, can we read that in a technical sense and say, well, they did engage in an assumption under the law of full responsibility, and therefore, can we do that if we're going to call it a mistake of law?
Judge, I think that's really reaching, because the essence of what is alleged that State Farm said is that we're going to pay for the injuries caused by our insured.
I think they said they're going to assume full responsibility.
This is a direct quote.
It's
Paragraph
right
4
out
of the
of
complaint.
I mean, we're not trying to pull a fast one on you. Right out of the complaint, the allegation is that they were going to assume, they were going to engage in the assumption of full responsibility for these injuries.
And Judge, that complaint was nullified with an amended complaint. So that complaint doesn't really, that's not the operative complaint anymore.
Did you raise that issue in your answering brief?
That was in our statement of facts, yes. If you read
that the amended complaint nullified the original, did you
well,
raise
no,
that
that
argument?
there was an amended complaint.
I understand that. I understand that.
All right,
Did you
let's
raise that argument?
Can I just ask this question? In the amended complaint, I haven't looked at it. Does it contain the same allegation?
No, it does not.
What's the allegation? In
The allegation.
complaint?
I'm sorry, Judge, I didn't mean to interrupt you. The allegation is that there was an accident caused by Miss Campbell.
Okay. So let me see if I can ask this question, because it's kind of affects both of the positions that you've been hearing about here. Is if the insurer says we'll be responsible, I mean, can they in fact do that? Can they say, yes, we'll be responsible, and subject themselves to suit on that promise? This isn't an indemnification. This is a direct representation that they will be responsible for the damage.
Excellent question. No, Judge. For the insurer to be subject to direct liability, there would have to be some sort of agreement or statutory provision making that the case, and there's no evidence of that here.
Well, I'm confused because I'm following up on Judge Norris's hypothetical, actually, where she, as an adult, she's walked across to her neighbor and said, "My adult daughter's caused this, but I'll pay for this." She doesn't have a legal obligation to do it, but she's voluntarily assumed an obligation. Can she be sued on that?
No, she didn't invite a direct lawsuit. She just offered to settle the claim.
Okay, well, we've probably distracted you from whatever it is you wanted to tell us here this morning, so why don't you, in your remaining time, go ahead and tell us what it is you want us to know.
The main point I wanted to make, Judge, was that this is a mistake of law in this case. The Flynn's thought that they could sue State Farm because they confused its duties to defend and indemnify with direct liability. And we know direct liability for negligence requires a breach of duty, and the Flynn's never thought State Farm breached any duty. And they knew, in fact, they knew the contrary was true. They knew that Ms. Campbell was in control of the other vehicle involved in the accident.
And so, just so I understand, your view is that that principle of law, that there can be no direct action against an insurance company, trumps whatever representation State Farm made to these plaintiffs about its responsibility and willingness to pay these damages.
I don't think it trumps anything. I just don't think it gives rise to a cause of action.
Well, that's not the issue, whether it gives rise to a cause of action. The issue is mistake. And yes, we understand we're a no direct action state. But when the plaintiffs have alleged that the insurance company assumed full responsibility for its insured's actions, just saying, look, this is what they told me, thinking, okay, I want to sue them because they said they'd be responsible, just from a factual standpoint. Doesn't that at least reflect a reliance on what they thought was the role of this entity? And so maybe they were mistaken. But isn't that a mistake of fact? Because they did not understand the nature of the responsibility State Farm was assuming.
Judge, I think that leads to a slippery slope that completely eviscerates the rule against a direct action against the insurer, because now all they have to do is say, well, they have to, a plaintiff could misconstrue the insurer's statement, we're going to indemnify our insured. Oh, they just said they're going to take responsibility.
This is the record we have. If Ms. Flynn improperly or mistakenly misrepresented her communications with State Farm, you could have given us, not you personally, but State Farm could have provided an affidavit from whoever the adjuster was that spoke with them. So we could perhaps maybe have a more developed record. But this is what we have. This is all we got. This is all we got. So therefore, given this, isn't there just a fundamental misappreciation, a factual misunderstanding based on the representation of assuming full responsibility that Ms. Flynn made?
No, because the mistake has nothing to do with the factual circumstances of the accident and who's responsible for it. And that's what the rule looks at, is who's liable for the accident. All this is sort of a tangent that really has nothing to do with that.
It says assumed full responsibility for its insured's actions.
And I don't see how that can create any confusion about who was liable for causing the accident.
We're not talking causation. We're talking a mistake in suing a party.
We're talking about liability, and that's what is required to satisfy the mistake of identity. You have to wrongly think that the named defendant is liable, and there's nothing here that shows that the Flynn's thought that State Farm was actually liable for the accident, because we know liability requires a breach of the duty. And Ms. Campbell was in control of the other car.
There's no question Ms. Campbell was in control of the car. She allegedly caused the accident. Okay.
Thank you.
But the issue then, according to the complaint, was, okay, who's going to be responsible for all the damages? They assumed full responsibility for its insured's actions, and then they go on to explain what their damages are or what their losses are in very general terms. So they're not talking about the accident. They're talking about being responsible for their losses.
I hear you, Judge, and I think, my point is that we have to look at the Rule 15C requirements, and a mistake of law just doesn't satisfy that. You have to have a mistake of identity, and that just doesn't exist here, because the Flynn's knew from the beginning that it was Ms. Campbell who was in control of the other car. And so absent any other questions, I think that relation back does not apply.
Thank you,
Thank you.
counsel. All right. Ms. Julian.
I think it's in debating the issue of what it means to make a mistake for Rule 15C, it's important to start where the Supreme Court in Timon starts and where the United States Supreme Court in Krupski starts, which is the definition of a mistake. A mistake is a wrong action or statement proceeding from faulty judgment, inadequate knowledge, or inattention. And evaluating whether or not a mistake has happened is done from the perspective, the actual perspective of the person who is seeking relation back pursuant to Rule 15C. In this case, the appellee is arguing that this was a mistake of law. But as I've pointed out, mistakes based upon the actual knowledge of the party making the mistake don't necessarily have the knowledge of a lawyer can be made even if, for purposes of Rule 15C, even if a lawyer in that same scenario wouldn't have made the mistake, because the lawyer's knowledge is fundamentally different from the knowledge of the party in this case.
So you're saying that we don't impute to a non-law trained litigant the knowledge of a lawyer the way we would under other circumstances.
Right, and I agree with Mr. Barnes that as a general proposition, pro per litigants are held to the same standard as lawyers. But when applying this particular requirement of the rule and the subjective test that the Arizona Supreme Court laid out in Timon, if you are looking at the perspective of this party, you have to include reference to the fact that she was unrepresented at the time. So her knowledge isn't the knowledge of her agent lawyer. Her knowledge is only her own knowledge because she filed the complaint on her own. And so that is the perspective from which we evaluate whether or not a Rule 15C mistake was made. And for that reason, in looking at the allegations, as this court has pointed out, Ms. Flynn, it's undisputed. There's no controverting evidence that she knew that State Farm's representations meant that it was only paying for the claim, but that she still should have been suing Campbell. The only evidence in the record, whether it's by reference to the original complaint, which I'd like to also point out that even though there's an amendment to the complaint, the purpose of the amendment was to correct the error that State Farm pointed out to her after she filed the original complaint against it. So State Farm is not seeking to utilize the benefit of the amended complaint. This appeal arises from the dismissal of the amended complaint. And the allegations of the original complaint, while they may not be binding judicial admissions for purposes of the car accident and the amendment, litigation of the amendment, they are judicial admissions to the extent they shed light on the plaintiff's knowledge at the time she filed that original complaint and whether or not the defense, both State Farm and its insured, knew or should have known that but for a mistake in her original pleading, she would have sued Campbell. I think that based upon the record in this case and Ms. Campbell's position as an unrepresented party, the representations that are undisputed that were made to her, telling her that State Farm would be assuming full responsibility for the conduct of its insured, that she believed, and she testified she believed at the record at item 16, paragraphs 4 and 5 of her affidavit, that for those reasons she actually believed that they were the proper party to the case. That's a Rule 15 mistake that the trial court erred in rejecting. As a result, we would ask this court to reverse the judgment of the trial court dismissing the amended complaint and enter an order on remand requiring that the amendment relate back in time to the filing of the original lawsuit. Thank you.
Thank you, counsel. We appreciate the the arguments you both have made here this morning. We're going to take this matter under advisement. We will issue a written decision in due course, and we're going to take a brief recess to allow the next group of parties to come forward to set up for the next argument. Thank you.